No, it is simply what your argument is ridiculous. Town Center Place versus Jacqueline King.
Right from the jump, this judge isn't here for games. You can feel it in her voice. Tired of excuses. Tired of delays. In this case, it's not just about a roof over someone's head. It's about the brutal red tape that low-income renters have to deal with just to survive.
She can have a seat there. All right. This is your motion.
Your Honor, we request her COD that Ms. King be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had been looking for new housing. I provided a letter from Ms. Little from Housing Europe Senior showing the properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also filed a
So when are her interviews?
Would you mind if Ms. Little comes up?
Yeah. That's fine. Okay.
So Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because there's still some paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She just needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not going to get a great option to move into. So it'd be nice if we got her from the others, but we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written conditional order of dismissal to be enforced. Part of the conditional dismissal order was that she paid rent, she paid full rent, she paid timely rent. And
This tenant's trying. She's applied to multiple places and she's been accepted, just hasn't had her interviews yet. That's not nothing. And honestly, anyone who's ever had to move under pressure knows how chaotic it can be. Now imagine doing that on limited income with paperwork hurdles at every turn. But the court isn't dealing in emotions, it's dealing in timelines and signatures.
We've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent, stated in conditional dismissal. She has not. She's been informed that she had been paid by a letter paying less both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the ledger that plaintiff submitted with their answer is not the ledger that they seem to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they
$79. That's the number hanging over her. You might think, come on, it's not even $100. But in subsidized housing, those numbers matter. It's not about how much, it's about what the agreement said. The second she didn't pay that full amount, it gave the landlord the leverage they needed.
claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
And here's where things start feeling shady. The tenant's lawyer says the accounting ledger was wiped unfairly, meaning past payments were deleted. And now it looks like she owes more than she should. If that's true, this isn't just a rent case, it's misrepresentation. But the judge isn't buying it.
I think it's in April or March.
It was January 16th, 2025.
January of this year
Yes. The effective date was March 1st, 2025.
of the rent. So it's March and April. That
And go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as
I recall. I
We
recall.
did that. So before that date, shouldn't be in controversy.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, supposed to be February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had since.
She was to zero out, that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay, well, Your Honor, the COD says that she abide by the terms of the lease. This is subsidized housing. Paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause for subsidized housing. They are required to offer payment arrangements. The goal is for subsidized housing.
She entered into a COD that she was going to pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And
This is ridiculous.
And there it is, the judge has had enough. When compliance gets blurry, judges want facts, not confusion. This is the moment where patience turns into a ruling.
It is simply what your argument is ridiculous. Because what I'm going to do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm going to deny the motion to extend the time.
This is the breaking point. Watch the judge's body language here, fed up, frustrated, and done. And I get it. Judges have to make decisions based on what's in front of them. But man, sometimes the paperwork just doesn't tell the whole story.
Thank you.
Yeah, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time
It
for the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
I'm sorry. Your Honor,
Yes.
the second line from the last line says defendant will pay March and April rent at normal time. Your signature is right here.
And she paid on the 5th.
She did not pay her full rent, ma'am.
Okay, but she paid on the 5th.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So Your Honor, we'll submit a writ.
Thank you.
Thank you.
Motion denied. Motion denied. Motion denied. It hits hard. No more discussions. No more leeway. That's it. She loses her request for more time. Maybe legally it's justified, but emotionally, it feels heavy, like the system isn't built for someone like her to win. So now I want to hear from you. Was this a fair call, or could the judge have shown a little more grace? Drop your thoughts in the comments. This one's going to have mixed opinions for sure.